Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. My name is Tony Farrar, and I am your instructor for this semester. Tonight's lecture is going to be on Chapter 8, where we are going to cover crimes against persons, more specifically assaults, sexual offenses, and other crimes. And we'll talk about battery and kidnapping and false imprisonment and threats and things like that as well. But let's go ahead and jump right into our Chapter 8 lecture. So, by way of introduction, on May 6th, 2013, Amanda Berry, who had just been freed from a home in Cleveland, Ohio, by neighbors who heard her screams for help, phoned 911 and told the dispatcher that she had been kidnapped, that she had been missing for 10 years, and that she is here now and that she is free. And with this telephone call, one of the most unusual and disgusting cases of abduction, sexual assault, and imprisonment in recent decades was brought to light. Now, keep in mind, we're talking a 10-year span, so hold that thought as I continue. The facts of this case began on August 22nd, 2002, when 21-year-old Michelle Knight disappeared. In April of the following year, Amanda Berry, who was 16 at the time, disappeared. And then 1 year later, Georgiana De Jesus disappeared, and she was only 14. Now, all three girls had been kidnapped by the same guy, Ariel Castro, who kept them imprisoned in his home for over 10 years. And during that time, excuse me, he beat them, he raped them, and actually one of the women gave birth to one of his kids. Now, Castro was charged with 512 counts of kidnapping, 446 counts of rape, 7 counts of gross sexual imposition, 6 counts of felonious assault, 2 counts of aggravated assault for killing the fetuses of the victims he impregnated, 3 counts of child endangerment, and 1 count of possession of criminal tools. Now, he entered into a plea agreement with the state of Ohio, through which he pled guilty to 937 charges. He was then sentenced to life imprisonment plus 1,000 years, and on September 3rd of 2013, he committed suicide by hanging himself with his bedsheet in a prison cell. So, an extremely complicated, complex, long, drawn out, interesting case as it relates to assault, rape, murder. I mean, you name it, it's in there, lasting over 10 years. And one might ask yourself, well, how could 3 people actually be held in captivity for that long without somebody finding out? And were there other people involved? And one point of note here, they really weren't that far away from home. While they were all kidnapped by the same person, they were, being held together. They were not far away from where they actually lived. So I have a link to a video that's about 60 minutes. You don't have to watch it, but maybe you should if you want to learn a little bit more about this case and a lot of the peculiarities that come about from this particular case, because it is quite, again, in depth. So with that being said, let's go ahead and jump into our regular lecture and let's talk about assault. So the subject of this lecture, again, is the legal and social dimensions of personal crimes, not including homicide, because that was back in Chapter 7. Now, note that there will be some overlap between many of the crimes that we talk about in this chapter. Some of these crimes kind of overlap. An example, rape, for example, is also an aggravated form of a battery. So, there's going to be a little bit of overlap, but I'll try to explain that the best I can. The crimes of assault and battery are a really good starting point for this lecture on personal crimes. And although today the terms assault and battery are often used together or interchangeably, under common law, they were very different and distinct crimes. An assault, simply put, is an attempted or threatened battery, and a battery, on the other hand, is a completed or consummated assault. Now, as one law expert puts it, when we speak of an assault, we usually have in mind a battery which was attempted or threatened. The attempt may have failed or it may have succeeded. If it failed, it constitutes an assault only. If succeeded, it is an assault and battery. Some state penal codes do not contain the words assault, and they replace them with the term attempted battery. Now, put more formally, an assault is a willful attempt or willful threat to inflict injury on another person. It may also include the act of intentionally frightening another person into fearing immediate bodily harm. And a battery can be defined as unlawful violence inflicted on another without his or her consent, or as intentional and offensive touching or wrongful physical contact with another without consent that results in some type of injury. So a lot of information here, but let's kind of break it down. An assault, an attempted or threatened battery. A willful attempt or willful threat, not an accident. I bumped into you accidentally, okay, to inflict injury on another person, and that's the reason they have willful in there. The act of intentionally frightening another person into fearing immediate bodily harm. Must either intend to commit a battery or intentionally frighten the victim into fearing immediate bodily harm. So that's where we're getting into the brass tacks of assault. Battery is a little different. The unlawful physical violence inflicted on another without that person's consent. Unintentional and offensive touching or wrongful physical contact with another without consent. So you can see the different things that are in there. That results in some injury or offends or causes discomfort. And this requires actual unauthorized contact with the victim. So one major difference between criminal assault and battery is that assault is a specific intent crime and battery is not. Battery is a general intent crime. And to break it down further, you could probably say an assault is an attempted battery. Excuse me, because once you complete the assault and you hit someone, then it becomes battery. Does that kind of make sense to everybody? So let's go into it a little bit deeper. The Model Penal Code defines assault as attempts to cause or purposely, knowingly, or recklessly causes bodily injury to another, or negligently causes bodily injury to another with a deadly weapon, or attempts by physical menace, threat, to put another in fear of imminent serious bodily injury. And along with that, there is this piece that comes in there that really has to be there. And it's called presentability. So there is a presentability element of the crime of assault that requires that the defendant be physically capable of carrying out the attempted act and the method he or she intends or threatens to use will in fact inflict injury or offensive touching if carried out. So that presentability piece is very, very important. Now, again, well, let's move forward on that. So the MPC, that model penal code, defines assault as, again, we're talking more, we're going to kind of continue down the road of assault. The term bodily injury simply means an unlawful application of physical force on the person or the victim. So that could be something as simple as a slap, because if you go back, I mean, typically it's not wanted. So again, we go back and we look at the section, kind of go back here, intentional, I'll go back here, willful attempt or willful threat to inflict injury. And then we go to battery, intentional and offensive touching, or wrongful physical contact with another without consent. So now we'll go back up to the photos here. The term bodily injury simply means an unlawful application of physical force on the person of the victim. And placing another in fear. The second type of assault under common law, the threatened battery type, was the placing another in fear of imminent injury. And in some jurisdictions, the crime is described as intentional frightening assault. So, or conditional assault. Either type of assault may be made upon the meeting, upon meeting the assailant's demand. So, for example, the bank robber's statement, "One false move and I'll shoot," is what we call a conditional assault. And these are things that are, again, listed in your textbook, and that's another reason to make sure that you look at all the terms and things that are listed inside there, so you have a good understanding on all of these different types of things. So again, placing another in fear. Okay, go back real quick. The second type of assault under common law, the threatened battery type, was the placing of somebody in fear. And in some jurisdictions, they call this intentional frightening. And then for under conditional assault, either type of assault may be made upon the meeting of the the person's demands. And I gave you the example of like the bank robber, making the statements right there. Well, then what then is an aggravated assault? Because now we've covered a little bit about assault. We'll get into the battery, but what is an aggravated assault? Well, in most jurisdictions, simple assault is one unaccompanied by aggravating circumstances. Simple assaults are classified as misdemeanors. Now, all jurisdictions, however, have recognized various types of felonious assaults, if you will, which they call aggravated assaults. And aggravated assaults are generally assaults with intent to commit some other offense, like rape or murder. As a result, aggravated assault is sometimes called assault with intent. And indictments for specific offenses, such as assault with intent to kill, are not unusual in criminal law. Aggravated assault was not an offense under common law. Now, special categories of assaults, such as assault with a dangerous weapon, assault on a police officer, assault on a school official or teacher, assault on a prison guard or correctional officer, and so on, have been classified in various jurisdictions as aggravated assault. So hence the term aggravated assault may mean, one, an assault that is committed with intent of committing an additional crime, or two, an assault that involves special circumstances, like some of those special categories of people that I talked about. So to prove an aggravated assault, the prosecution must successfully show that the assault took place as part of another more serious offense, or that an assault occurred with aggravating elements specified by law. So again, an aggravated assault occurs when a person attempts to cause serious bodily injury to another, or causes such injury purposely, knowingly, or recklessly under circumstances manifesting extreme indifference to human life, and attempts to cause or purposely or knowingly causes bodily injury to another with a deadly weapon. And this is something that these two things here are ideas that were placed in the Model Penal Code's definition of aggravated assault. So that's, again, the framework when we talk about the Model Penal Code. So although, again, common law assault was in most cases an attempted battery, the law pertaining to criminal attempts generally does not apply to assaults. Now, with that being said, let's look at battery. And let me clear that up. I just want to make sure that you know the attempted assault kind of thing. Let's read that again. You know, we know that an assault is kind of like an attempted battery. So think about that. Can we have an attempted attempt? So just to clear up any rough edges here, although a common law assault was in most cases an attempted battery, the law pertaining to criminal attempts generally doesn't apply to assaults. And this is partially the result of historical exigencies under which the common law on assaults developed earlier and independently of the common law on criminal attempts. So, you know, again, because an attempt is, you know, an assault is an attempt battery, we can't really have an attempted assault, if that makes any sense. So let's go to, we spent enough time on that. Let's move to battery and let's talk about what that is. Well, as noted earlier, the crime of battery is either the causing of bodily injury or the offensive touching of the person of another. And battery has three elements: the willful and unlawful, use of force or violence or offensive contact against the person of another. And one thing to note, no injury to the victim needs to occur under this type of, under this particular section. Now, although in most cases battery is an intentional crime, it may also be committed recklessly or with criminal negligence. And the Texas Penal Code, for example, makes it a crime to intentionally, knowingly, or recklessly cause bodily injury to another. So just to kind of you know, make sure that we understand that. And it is not necessary, again, for the victim to actually fear physical harm as the result of the touching or injury. To determine if the touching was offensive, look to see if a reasonable person would be offended by the touching. And transferred intent, as they call it, can apply to the crime of battery. So let me kind of walk you through that a little bit. So the doctrine of transferred intent does apply to the crime of battery. Accordingly, if an assailant intends to injure one person and by mistake or accident injures another, he or she is guilty of battery. If, for example, a defendant intended to hit his girlfriend with a baseball bat, but in swinging the bat accidentally hits her son instead, the defendant would be guilty of battery on the son via transferred intent. and also guilty of assault on his girlfriend. So hopefully that kind of clears that up a little bit. And another couple of phrases that come in under battery are going to be three that we'll discuss quickly. Is something called constructive touching, sexual battery, and effective consent. So constructive touching is considered sufficient to sustain a battery charge. Now, in one case, for example, a defendant was convicted of battery when he hit a horse that the victim was riding. In another case, a defendant was convicted of battery when he got a young female child to touch his genitals. Constructive touching is touching that implied by law to replace the touching requirement, where the defendant gets the young female to, do the touching, or where the defendant touches, something that the victim is wearing. So hopefully that kind of makes sense. Now, in most jurisdictions, the crime of battery is a misdemeanor unless there are special conditions associated with that that aggravate the crime. And again, we talk about different codes that fall under here. So battery on a peace officer, battery with the intent to inflict death or serious bodily injury. These are things that would aggravate that crime. In most jurisdictions, the crime of battery is a misdemeanor again, unless there are special circumstances. So battery with the results of serious bodily injury, or what we call sexual battery. And this is the unlawful touching of an intimate part of another person against that person's will and for the purpose of sexual arousal, gratification, or abuse. So last in this area of the three things I wanted to go over with battery would be effective consent. Effective consent of the victim, also called legal consent, or the defendant's reasonable belief that the victim legally consented to the conduct in question, is a defense to the charge of battery if the conduct did not threaten to inflict or actually inflict serious bodily injury. And effective consent is consent, again, obtained through a legal means or legal manner. Well, what about aggravated battery? Well, as is the case with the crime of assault, some jurisdictions have created the statutory crime of aggravated battery. And aggravated battery did not exist under common law like the crime of aggravated assault. Aggravated battery may involve the use of a deadly weapon. It may involve acts committed with the intention of committing another crime, or it results in serious injury. And that brings us to the section of mayhem. So again, we're talking about in this chapter crimes against persons. And mayhem is a battery that causes great bodily harm or disfigurement. And it has three elements. The first one is the unlawful battery. The second one is involving maliciously inflicting or attempting to inflict a violent injury with one or more disabling or disfiguring injuries resulting from the particular illegal action. Now, California law says, and it gets a little bit more descriptive, every person who unlawfully and maliciously deprives a human being of a member of his body, or disables, disfigures, or renders it useless, or cuts or disables the tongue, or puts out an eye, or slits the nose, ear, or lip is guilty of mayhem. So you can see that, again, there are some different elements, if you will, depending upon what state that you're talking about. But typically, again, the model penal code is the basis for quite a few of these different sections. Excuse me. So another section that falls underneath the crimes against person would be stalking. And kind of as an intro, in 1997, 41-year-old Cheryl Vivier donned a beard, glasses, and a baseball cap and posed as a fisherman. With 2 guns in her waistband, she entered the office of Alligator Lakeside Inn in St. Cloud, Florida. George Long, her 45-year-old ex-boyfriend and co-owner of the motel, was working behind the desk. Now, a struggle ensued, and Long wrestled one of the guns away from Vivier before she pulled the other out from her clothing and shot him 4 times in the chest. Long died at the scene, and Vivier shot herself soon afterward. The two had dated for several years before breaking up a few months earlier. And after the breakup, Vivier had relentlessly pursued Long and had been arrested for trespassing and charged with aggravated stalking under Florida law. So the strict requirements needed to establish the crime of criminal assault have led many to believe that traditional criminal laws are not adequate to encompass the conduct of stalkers. And accordingly, many jurisdictions have extended the scope of their assault statutes to include intentional scaring or stalking. The very first anti-stalking statute was enacted in California, and it reads as follows: any person who willfully, maliciously, and repeatedly follows or harasses another person and who makes a credible threat with intent to place that person in reasonable fear of death or great bodily injury is guilty of stalking. So again, now let's look at the definition. The intentional frightening of another through following, harassing, annoying, tormenting, terrorizing activities. And it also extends to cyberspace now, because there is plenty of stalking as it relates to computers and Facebook and Snapchats and Instagrams and all the other types of technology that is out there. So that is kind of covers a little bit of the stalking. And now we're gonna move into briefly talk about a couple of different sex offenses. So few areas of criminal law have attracted as much attention and as much controversy in the past 25 years as the attempt to place legislative controls on sexual behavior, and efforts to estimate the extent of sexual crime in our society also stirs controversy. And one reason for the controversy is that in recent years, attitudes about sexual relationships have been in a state of flux. People generally agree, however, that unwanted and unconsensual sexual activity should be subject to criminal prosecution, and that sex with children under the age of legal consent should be criminalized, meaning punished. Statistics show that non-consensual sexual behavior is relatively common. In one study, for example, researchers found that 27% of all college-age women had been victims of rape or attempted rape, and that a number of the women had been victimized more than once. So that leads us into the definition of criminal sexual conduct. And criminal sexual conduct is a general neutral term that is applied today to a wide variety of sex offenses, including rape, sodomy, criminal sexual conduct with children, and deviant sexual behavior. So probably one of the sections that people hear the most about, whether it be in the newspaper or on the news or what have you, would be what we call rape. And this is going to fall under one of these sex offenses, of course. Now, although the penal codes of many states today recognize that both males and females can be sexually assaulted, common law, defined the crime of rape as the carnal knowledge of a woman forcibly and against her will. And the term carnal knowledge meant sexual intercourse. Now, it has been replaced with the term sexual intercourse in many contemporary statutes. And for centuries, courts required that a woman must resist to the utmost of her ability. And that resistance must continue until the woman is physically overcome or until the offense is complete. Now, no states adheres to the utmost resistance requirement today, although some continue to require reasonable resistance on the part of a conscious victim, while recognizing that resistance can be overcome through threats. So with that being said, let's look at the exact definition. Sexual intercourse with a person who is not the spouse of the perpetrator. And also one thing to add now, rape is not gender specific. It's male or female. So either one of those, I mean, it doesn't really matter, like it used to matter before. So back in common law, where it was specifically, the section was aimed towards a woman, if you will, it's not like that anymore. So rape in most jurisdictions is sexual intercourse with a person who is not the spouse of the suspect. And the reason for that is because, as you will see, there is a separate section for what we call spousal rape. So right now, spousal rape is a crime in all states. So, and we'll get into that a little bit more. So sexual intercourse with the person who is not the spouse of the perpetrator through force, through the threat of force, or by guile, which means fraud or trickery, and I'll talk about that in a second. And without the lawful consent of the victim. And consent is going to be different in different states. And we'll talk a little bit more about consent, but I just want to make that very, very clear. That consent could be different in different states. Well, what do you mean by guile or fraud or trickery? And the example reminder for me to talk about would be this fake marriage. So let's suppose that we have two guys, and they're both adults. Let's just say they're 20 years old. And one of the guys has a thing for a neighbor. And this neighbor is an adult. Let's say that she is a 19-year-old woman. And let's just say that he asks her out and they they date a couple times and nothing happens, and they're just kind of friends and this and that. Well, they start to get a little bit more serious, let's say, in their relationship. And he finds out that she happens to be extremely religious in the fact that she is to remain a virgin, if you will, until after she is married, to when she could then consummate her marriage. And that's part of her belief. And she adheres to that belief. So one of the one that's dating the woman decides, well, you know what? I'm going to get you my buddy, and I'm going to ask her to marry me. And if she says yes, you're going to pretend to marry us. And after the pretend wedding, and we sign the forged fake wedding certificate, if you will, then I'll be able to have sex with this woman. And then later, somehow she finds out. Now, there's a lot of other issues relating to this, whether it's forgery and some other things, but did she lawfully consent, or was she tricked through fraud or trickery? A very, very interesting case, and something for you to kind of think about. So back to, real quick, I talked about spousal rape is valid in all 50 states. And at common law, a husband could not rape his wife because it was believed that when a woman married, she consented to sexual intercourse. And now things have evolved, and we know that that is not true. Okay? So just kind of keep that in mind as well. Another thing that we'll need to know as far as definition is what we call forcible rape. And this is non-consensual sexual intercourse accomplished against a person's will by means of force, violence, duress, menace, or fear of immediate and unlawful bodily injury to the victim. Now, in the past, many rape statutes emphasized the role of force in the crime of rape, giving rise to this term now, forcible rape. And I gave you the definition, but let me give you Maryland's definition. So under Maryland law, for example, a person is guilty of rape in the second degree if the person engages in vaginal intercourse with another person, one, by force or threat against the will and without consent of the person. Now, in most jurisdictions, the crime of rape requires that the unlawful intercourse must be committed by force, fraud, or compulsion, except for those situations in which the victim is incapable of giving legal consent. And consent cannot be given by a victim who is a minor, who is mentally incompetent, or someone who is unconscious. And we'll talk about that, I think, in a couple of different sections here. So most jurisdictions distinguish between various degrees of rape. First degree or aggravated rape is often defined to include one or more of the following: an armed offender or serious bodily injury to the victim. First degree or aggravated rape, again, might include an additional felony where the rape occurs during the commission of some other crime. So an example could be if somebody breaks in to commit a burglary, and while they're inside the home, they find an individual in there and they commit that crime. So they've committed an additional felony, or a gang rape. And all of these, again, are things that could fall under first degree or aggravated rape. So with that being said, it's probably good for us to understand what lawful consent means. Now, in individual cases, the question of whether intercourse was consensual may be difficult to answer. If the victim is incapable of giving legally effective consent, then intercourse with the victim is rape, even if he or she express words indicating consent. The fact that a victim consented to sexual foreplay, if you will, does not mean that the victim consented to intercourse, nor does the fact that the victim had in the past consented to intercourse with the defendant to constitute consent on the present occasion. A difficult question arises in situations in which the victim remains silent and offers no resistance. Most jurisdictions require that the victim, if conscious and able to communicate, must in some manner manifest his or her objection to the act for it to constitute rape. Now, a lack of consent can be established by any acts of the victim that would lead a reasonable person to believe that he or she does not consent to intercourse. And in most jurisdictions, a reasonable mistake as to whether the victim consented is a defense to rape. In a case that made headlines during 1993, Joel Valdez, dubbed the condom rapist, was found guilty of rape after a jury in Austin, Texas rejected his claim that the act became consensual once he complied with the victim's request to use a condom. Valdez, who was drunk and armed with a knife at the time of the offense, claimed that his victim's request was consent. Now, that case, again, he was convicted, so you can see that that didn't apply. So that's the essence, if you will, of lawful consent. Well, what about this statutory rape thing? And we're going to turn to age for just a moment. So all jurisdictions have laws defining statutory rape, and this is anyone who has intercourse with a child below a certain specified age. They're guilty of statutory rape. It's a written law. It's statutory, whether or not the child consented. And this is statutory rape is what they call a strict liability offense. So you have to kind of ask yourself some questions under this particular law. We know that sometimes there are instances in which someone that's 18 might be with someone that's 17. And again, I'm not imploring the moral concept here for us to discuss. I'm just talking about real life situations for us to think about whether or not a 17-year-old has ever had sex with an 18-year-old. And it doesn't matter what gender, you can flip it either way you want. Whether the woman is 17 or the woman is 18 or the guy is 17 or the guy is 18, doesn't matter. Statutorily, especially in California, if you're under 18, you can't legally consent. So, questions come up typically about whether or not this is a law that's appropriate. We know why we have these types of laws, because we're trying to protect our children and also have an age limit to where we believe people can consent to certain things. But sometimes there is some criticism on this particular law, and California's can be found under Section 261.5. So that's my soapbox on that. But just understand that this could be something that could come up, and again, it's statutorily written, and it is a strict liability offense. Well, what about same-sex? Now, the common law definition of rape required both 1, penetration, and 2, an unwilling female victim. And accordingly, it was generally held that there was no crime of homosexual rape under common law. Now, today, however, a majority of jurisdictions have rape statutes that are gender neutral, and they should be, at least in my belief. Don't get mad at my belief, but that's what I think. Because I think you can be a victim of this particular type crime, and it doesn't matter what gender you are. Now, in those jurisdictions, intercourse between people of the same gender may be rape if all of the other elements of the crime are present. And in a few states like New York, they have gender-neutral rape laws by virtue of a court ruling rather than a statutory legislation or a law. So similarly, a woman can be convicted of the rape of another woman when she forces a man to have non-consensual sexual intercourse with the victim. In a 1971 California case, for example, a female defendant who forced her husband to have intercourse with a young girl at gunpoint was convicted of rape. So again, interesting case laws, and again, they're different from state to state, but just understand that a lot of these laws have evolved and they are becoming better. They may not be perfect, but we're starting to see a lot of good laws that are out there. And what about this thing called Rape Shield? And you may have heard this before. So a Rape Shield law, this is a statute intending to protect victims of rape by limiting a defendant's in-court use of a victim's sexual history. And these laws mandate that the probative value or worth of any particular information about a woman's sexual history be demonstrated before the evidence can be presented at trial. And this typically makes the cases a little bit more fair. And if you want to know what probative value means, that's the worth of any evidence to prove or disprove the facts at issue. Affirmative consent laws, these policies go a step further than rape statutes in protecting victims. Silence is not an affirmative consent, and the existence of a sexual relationship, part or present, does not matter. It's immaterial. Created in a response to the frequency of sexual assaults on college campuses. And they're broader than the common law crime of rape, and they may include the common law crimes of rape, deviant sexual intercourse, unlawful sexual contact, and even statutory rape. So quickly now, let's move into the realm of kidnapping as we finish up this chapter. So kidnapping and what we call false imprisonment are crimes that intimately invade a person's privacy and take away their liberty, often in abrupt and forceful fashions. Now, kidnapping is generally defined as the unlawful removal of a person from the place where he or she is found against the person's will and through the use of force, fraud, threats, or some other form of intimidation. Now, under early common law, kidnapping consisted of the forcible abduction or stealing away of a person from his own country into another. And somewhat later, the requirement was modified to require involuntary movement merely from one county to another. Today, most jurisdictions hold that any unlawful movement of the victim is what we call substantial and is sufficient to satisfy movement, or what we call asportation, that requirement inherent in the elements of kidnapping. And today, most common legal issue in kidnapping cases is whether the person was forcibly moved against his or her will, and not the degree of movement or distance. So the elements of kidnapping generally are an unlawful taking and carrying away, also known as asportation. So carrying away or taking or moving is asportation of a human being by force, fraud, threats, or intimidation against the person's will. And in some jurisdictions, kidnapping may also be committed by the use of deadly force to confine the victim, or by confining the victim for purposes of extortion, ransom, or sexual assault. Excuse me. And there are some separate sections like kidnapping for ransom, if you will. Real quick, just a couple of other things, and then we'll move to false imprisonment. The laws of some jurisdictions provide for more than one type of kidnapping. California law, for example, recognizes 4. 1, forcible kidnapping. 2, kidnapping with the intent to commit certain felonies. 3, kidnapping with the intent to take a victim out of state. And 4, being kidnapped or being a kidnapped victim into state or bringing one into state. California law also specifies penalty enhancements for kidnappings that are committed for the purpose of committing a sexual offense for ransom, like I said, extortion, or robbery, and for kidnapping a child under the age of 14. So a lot of different variations in the law, but here, as I showed you, these are the key elements. What about false imprisonment? Well, this is the unlawful violation of the personal liberty of another. It is similar to kidnapping, except that it doesn't involve the carrying away of the victim, that asportation. Okay, so kind of remember that. And just as laws of different jurisdictions vary as to what constitutes kidnapping, they also vary on how the confinement must be accomplished for the law to apply. A few jurisdictions do not classify an unwilling movement of an individual accomplished through fraud or kidnapping, holding instead that force, intimidation, or threat must be used for the offense of kidnapping to apply. So again, a couple of different variations here. So what are the elements then of false imprisonment? An unlawful restraint by a person of another person's freedom of movement without the victim's consent or without legal justification. So although the confinement must be accomplished by actual physical restraint, the application of force is not essential for this particular crime. Confinement, again, may be accomplished by threats or by some other action of the defendant that restrains the victim's freedom of movement, and the victim must be aware of that particular threat. So confinement must be unlawful in that there must be no legal authority for confinement. False imprisonment is a lesser included offense of the crime of kidnapping, and kidnapping is generally a far more serious crime than false imprisonment. So if we look at these two together, we can see a couple of the differences. So what constitutes then a threat as we're kind of winding down here towards the end of a chapter? Well, a threat generally requires communication of a message that is intended to cause another to fear for life or limb that would put a reasonable person in fear of life or limb. And as we talk about threats, just remember the First Amendment free speech guarantee. While it does allow you to say certain things, it limits things under these threat statutes. So there is a limitation on some of the threats or things that you can actually say, if that makes any sense. Okay, so I know that was quick, but we made it under our 60-minute time limit, so that's great. So don't forget, a couple of reminders, make sure you look through the summary portion at the end of the chapter to hit the high points, and also please go back in and take a look at the key terms in your textbook, or remember that I have a list of the key terms in your Canvas shell. So with that being said, that will conclude the lecture for chapter 8, and until next time.